Dear colleagues, dear candidates, and the public, advisory group of experts came together on 5th of December and tomorrow, 6th of December, to conduct interviews with candidates for two vacant positions of the judges of the Constitutional Court of Ukraine who participate in the competitive selection announced by the Council of Judges of Ukraine under the quota of appointment by the Congress of Judges of Ukraine. These interviews are part of the stage of assessing of the candidate's compliance with the criterion of high moral qualities. We remind that on the 2nd of June 2025, the Council of Judges of Ukraine announced a competitive selection for two positions of judges of the Constitutional Court of Ukraine. On 29th of August 2025, the advisory group of experts received from the Council of Judges all documents about all candidates. As of today, in this competitive selection, the candidates continue to take part, whom you will observe direct during the interviews. After receiving the candidates' documents, the advisory group of experts, in accordance with the requirements of the law of Ukraine on the Constitutional Court of Ukraine, collected materials and information regarding these candidates, including responses to inquiries to state institutions and organizations, as well as the own replies of the candidates to written requests. I would like to remind that one of the important objectives of the interviews is to provide the candidates an opportunity to openly explain to the advisory group of experts all the problematic matters about candidates, absolutely not diminishing their positive qualities and achievements. For the interview, we only propose problematic matters. The objective of the interview is also to disprove any doubts about the moral qualities of candidates. Dear colleagues, now we start the interview. The advisory group of experts is now in full membership for the interview with the candidate for the position of the judge of the Constitutional Court of Ukraine, Mr. Ihor Zavalniuk. At the meeting, all 6 members of the advisory group of experts are present: Secretary Orin O'Connor, member of the advisory group of experts, Hanna Sokotska, members of the advisory group of experts, Mr. Aller Saller, Yaroslav Romaniuk, Vasil Shakun, as well as myself, the chairperson of the advisory group of experts, Oksana Vasilchenko. During the interview, there are 5 deputy members of the advisory group of experts: Mr. Kuzmenko, Mr. Thomas Griffin, Mr. Richard Barrett, Mr. Marek Zumik. We are working in the shelter. In case of air alert, the interview will continue without interruption. We remind that there is a video recording of the interview and it's broadcasting live on the resources of the advisory group of experts and the website of the Constitutional Court of Ukraine. We draw the attention of the members of the advisory group of experts and the candidate about the constraints in using of sensitive data and information with restricted access on the air. If necessary to discuss such matters, the advisory group of experts will also limit the broadcasting for this time. We are ready to start. I would like to give the floor to the Secretary of the Advisory Group of Experts, Madam Maureen O'Connor, for brief introduction of the candidates and to remind the rules of the interview. Maureen, please have the floor.
Colleagues and everyone who is watching us. As our chair has already said, the advisory group of experts will now conduct an interview with the candidate Ihor Zavalniuk. Let me remind you that the interview is a mandatory stage of evaluating candidates as part of assessing their compliance with the criterion of high moral qualities. One interview is given approximately up to 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask all candidates to be concise and to answer clearly, unambiguously, and to the essence of the questions asked. At the end of the interview, the candidate may make a short final statement of up to 5 minutes. I would also like to note that during the processing of materials about candidate Zavalniuk, the advisory group of experts sent him questions to provide written explanations, so the candidate has had the opportunity to prepare and to provide answers. So now we have with us a candidate for the position of judge of the Constitutional Court of Ukraine, Ihor Zavalniuk. He is a judge of the Odessa District Administrative Court. He is an experienced legal professional with more than 22 years in the legal field and over 19 years of judicial experience. He began his career as a state enforcement officer, later worked as an assistant to the head of a court, and has served as a judge since 2005. Since 2009, he has been a judge of the Odessa District Administrative Court, where he also worked as deputy head of the court, and he currently serves as the court's spokesperson. He holds a full higher legal education and has a Doctor of Law degree. His doctoral dissertation was titled Constitutional Foundations for Ensuring the Right to a Fair Trial in Ukraine. He also has registered copyright for his work. He has taken part in traditional programs and actively participates in projects related to the development of mediation. He combines his judicial work with academic and teaching activities. In addition, he has already participated in the competition for positions at the Constitutional Court of Ukraine and was interviewed by the advisory group of experts in May of 2025. Mr. Zavalniuk, if you want to add something to your presentation, you can do it now for up to 3 minutes.
Дякую за представлення. Хотів
Thank you for this introduction. I would like to clarify that I'm not the deputy chairman of the court. I was the one for 20 years after 2014 till 2017, after the Revolution of Dignity, and now I combine the judicial activity with lecturing. I'm also a professor of the Department of the International Humanitarian University. Everything else is correct.
Colleagues, we will begin with the questioning.
Дякую, пані секретар. Ігор Вікторович.
Thank you. So, Igor, this year you already took part in the competition for the position of the judge of the Constitutional Court. I would like to remind you that from the Council of Justice, the judges, the advisory group of experts received the documents on 17th of May 2025. The interview took place with you by the advisory group of experts. Following the results of the interview, your candidacy was admitted, which does not meet the criteria of high moral qualities for the objectives of selection of candidates for the position of the judge of the Constitutional Court of Ukraine. So, Ihor, did you examine this negative decision of the advisory group of experts? I did not receive the decision because I expected this decision at the same time. I have analyzed carefully all the warnings that were discussed during the interview, and also in questions and answers and communications which was beforehand. I would like to remind you, as a doctor of law on the constitutional law, that the requirements of the law of Ukraine is the Constitutional Court that by the request of the candidate, the decisions are published about non-conformity with criteria of high moral qualities. Ihor, if you understand the problems that were the basis of the negative decision of the advisory group of experts, do you have any additional explanations about the facts which became the reasons for taking such a decision? Thank you for this question and the ability to clarify my position. First of all, my motivation to participate in the competition is the same, is to serve the Constitution in the most difficult times for our country. The first attempt of my participation in the competition demonstrated that I underestimated the importance of full transparency. I have deeply analyzed all the concerns, and I'm ready to provide all the complete answers. Also, I was motivated for the second competition by the support from the part of the chairperson of the advisory group of experts, and this gave me hope that my position during the second competition can be heard. I would like to demonstrate my ability to admit my mistakes and demonstrate my growth. I believe this is the most important value for the judge of the Constitutional Court of Ukraine. So, Ihor, I would like to remind you that the First group of questions, which is the basis of the negative decision, are the doubts about your academic integrity. I would like to remind you that in particular, the careful attention also found three articles which were a basis for your candidate's dissertation. This is a topic of dissertation. We will not repeat the topic of your thesis and as it became the subject matter of the research, those papers have been published after the defense of your candidate's thesis. We shall not repeat what you said before. The purpose of repeated interview is only clarification of the facts and circumstances which are not subject matter of the discussion during the previous interview. Therefore, we would like to request you to focus your attention on the new facts or the new arguments about the doubts of your academic integrity. I understand this concern. I would like to draw your attention on the main thing, that absence of the publication was not a falsification. It was negligence of the control over the publication, which demonstrates the fact of absence of falsification. First of all, if it were falsification, I would not do that in such a primitive way, because this would not be logical. I would never have referred to the sources which are easy to be checked if they did not exist. Also, at that time, I had 9 papers which have been ideal and caused no questions, and the minimum number of papers for to defend the candidate's thesis was 3. I already had 6. I had no reason to falsificate another 3 papers if the requirement was met. It's not logical at all. I would like to inform that all these discrepancies have been rectified, not for self-defense, just to defend the principle of academic integrity. And the evidence is my doctor's thesis, which caused no questions. I don't deny these allegations. I do not shift the responsibility to the university or the department. Yes, I admit that actually this was my insufficient control. Thank you. Ihor, another group of questions was about approval by yourselves in October of 2015 of the decision where the plaintiff was your scientific supervisor, Professor Kivalov. The advisory group of experts made the conclusion that there was a conflict of interest. Do you have any additional data that have not been subject matter of review by advisory group of experts on the previous competition? Let me explain. Indeed, I've reviewed that case in October, electoral case, and I did not realize the possible conflict of interest because before 2017, personally, I did not communicate with Mr. Kivalov, Sergei Kivalov. I also believe that I tried to clarify those matters when the university notified me. Of course, I was obliged to verify this data, and this is my mistake because I was insufficiently careful. Currently, I carefully check any official document before I participate in any activity. Over this time, I changed and my service list for the last 5 years proves that I have learned this lesson. For example, in the year 2024, when I completed my doctor's research on the topic of fair justice, a separate part, 4.2, was focused on the research of the matter of neutrality and objectivity, impartiality of the judge when reviewing the case, which is the foundation of fair and independent trial. Also, in May of 2025, in the National School of Judges of Ukraine, I separately underwent periodic training in order to improve my qualification on the topic of conflict of interest. I have clarified a clear protocol before every case I check all possible connections like family, professionals, even indirect. If there is any doubt, I withdraw myself from the case. As I have learned, this lesson is confirmed by two decisions in 2025, which demonstrates this. When I preventively refused from participation, special attention is deserved my latest decision of 2025. I have received the claim of the judge with whom since 2009 and 2010 I have worked together, and also we have been part of joint collegiums. We had collegial relations, and I refused from participation. And in this decision of 10th November 2025, I clearly stated that the court is convinced that even formal connections require refusal from participation in the case. No professional task is more important than trust of the society to impartial court. Being guided by a higher standard of impartiality and trust, the court believes it necessary for a preventive withdrawal. I have learned this lesson, and in my practice every time, in case if there is indirect or direct doubts, I declare self-withdrawal. And such a principle I will observe if I become a judge of the Constitutional Court, because I believe that no professional task is more important than absolute trust and absolute confidence from the society. Hanna, do you have any questions?
I can a question concerning the cash at expenditures, because according to your declarations for the period from 2019-20, you did not have any cash savings that would be subject to declaration. The same situation is in the declaration 22, 23, 2024. At the same time, you had a fairly high level of official income and did not declare significant expenditure during this period. Did you really not have any monetary assets to your possession in these years? Did you have any expenses that were subject to the declaration? Please explain it, because exactly we have to now decide on the moral integrity, and all the question concerning the cash and expenditure are of great importance for us.
Дякую за запитання, оскільки дійсно важливо.
Thank you for this question. The matter of financial transparency is really important. Yes, indeed, our family before 2019 had the savings which are represented in the declarations. And with that, in 2019, the expenses were made by our family. My wife bought the parking space in order to park the vehicle. And in this connection, after 2019, our savings became zero. And from that period, we also began to build up the savings.
The thing is that the legislation envisages that to declare the cash is necessary in the case when for each member of the family it exceeds 50 life minimums. And this is about 120,000 hryvnia for each person. Taking into account that the country at the beginning, we had COVID, and then we had martial law that was introduced, military actions started. My family, my wife and I, we did a lot of volunteering activity. We helped those who have suffered and who have been affected by the technogenic accident with the Kakhovka Dam. And as a result of the war, I helped Kherson region, because I was born in Kherson itself, and this is my homeland. So we made expenses, but they did not exceed they did not exceed 50 minimum wages. So we did not declare, according to the legislation, we did not have to declare the cash. That's but that's briefly. Also, we are helping armed forces of Ukraine on a monthly basis. Dear colleagues, do we have any more questions to the candidate? If there are no questions, Ihor Viktorovich, you have time up to 5 minutes to make your final summary, and then we will finish. Thank you. Dear members of advisory group of experts, I'm here in front of you, and this is not just attempt to receive the position. This is the intentional act of responsibility. After the last competition, I did not put aside your comments and warnings. I took them as a roadmap for growth. And at the moment, yes, my experience as a judge is 20 years. At first, I was appointed as a judge when I was only 26 years old. In the course of this time, I have adopted many decisions. Truly, part of them were debatable. It would be quite logical to convey the correctness of the decisions I've made or the legal lodging issues, negligence in control on publications, and wrong selection of a recommendator. This happened in the historical conditions. I'm not justifying any of those mistakes. I made mistakes and I have changed. And my actions since 2015, they demonstrate application of these lessons learned. I think that every mistake taught me the most important thing is to see not just the letter of the law, but also to see the justice. What is better for the Constitutional Court of Ukraine? The judge who says who never made mistakes, or judge who acknowledges mistakes and wants to grow? I want to suggest to you the second option. This is a rare case in the judicial system. This is a judge who doesn't not know only the law, but who understands the difference between the legal and the right thing. This is the judge who have changed 3 preventive self-exclusions. And in 2012, I have refused the incentives, the brilliant and excellent doctor's dissertation about just proceedings. This is my personal transformation. My 20 years at the position of the judge, this is not only 10,000 cases and materials, but this is the evolution from the young judge of the post-Soviet judge to the new standards. Yes, I had debatable episodes, and I already went through public critics. I know what it means to be mistaken and how to be corrected. And when I get under the pressure in the Constitutional Court, I will not be lost, because I have already been there. I have gone through this before. Who better understands the value of justice? The one who had an easy way, or the one who made mistakes and corrected himself? I think my experience had formed moral immunity. Candidate without mistakes, very often this is the candidate without solutions and decisions. I want to suggest maturity and not sterility. Dear members of the advisory group, Constitutional Court is at the crossroad. War, crisis, challenges. The state needs the judge who is not afraid of the pressure, who understands the balance of security and rights, who's honest with himself and the society. I think that people trust not those who never made mistakes, but those who is honest about it and who demonstrates changes. My biggest value is not the absence of mistakes, but ability to acknowledge them, analyze them, and not repeat them again. I ask you, dear members of advisory group, please assess me not by the ideal pattern of the past, but by the trajectory of change and readiness towards responsibility. I'm going to the Constitutional Court not to receive statues, but because I have energy, strength, experience, and will to protect Constitution. I'm ready to be that kind of judge. Thank you. Thank you, Ihor Viktorovich, for your answers, dear colleagues and the public. At the moment, the interview with the candidate, Mr. Zavalniuk, is declared to be